5 different methods Medicaid can use to claim your home after your death are buried in a federal statute that most older Americans have never even heard of, yet every state in the country is obligated to enforce it. As a result, the typical family loses over $300,000 in home equity simply because no one warned them what was coming. This statute is known as the Medicaid Estate Recovery Program. It was enacted by Congress in 1993 and mandates that each state pursue repayment from the estate of any person who received Medicaid-funded long-term care after turning 55. That includes Medicaid payments for nursing homes, assisted living facilities, and in-home care services. Most older adults believe that when they pass away, their home will automatically go to their children. But if Medicaid covered even a brief period of care before death, the state steps in before the children receive a single cent. In many situations, the house must be sold. The sale proceeds are forwarded to the state, and whatever remains, if anything, goes to the family. Frequently, there is nothing left at all. One of these 5 methods is the one almost no one anticipates, because it reaches assets your parents believed were completely out of the government's reach. I will reveal which one that is at the end. First, let's walk through how this really operates. The first way Medicaid takes your home is the most straightforward. It is called a probate estate claim, and it occurs in all 50 states with no exceptions. When someone who received Medicaid dies, the state asserts a claim against that person's probate estate. The probate estate consists of everything distributed through a will. If the property is titled solely in the deceased person's name, it becomes part of probate. The state submits its claim before the will is carried out. That means the Medicaid tab gets settled first. The children receive whatever remains afterward. Consider the numbers. If a parent received 3 years of nursing home care at $120,000 per year, the state's claim totals $360,000. If the house is valued at $400,000, the state absorbs nearly the entire property's worth. The children divide the remaining $40,000. This scenario plays out every day in every state. The government does not need a separate court order. It does not have to sue the heirs. It simply files a claim during probate. And under federal law, the probate court must pay that claim before honoring inheritances. There is a little-known exception. The state may not recover while a surviving spouse is alive, or while a child under 21 is living, or while a child who is blind or permanently disabled is still alive. But when the last protected individual dies, the state comes back. It can wait 10, 20, even 30 years. The claim does not vanish. So if your father dies and leaves the home to your mother, Medicaid cannot seize it while she is still living. Once she passes away, however, the state sends a notice. It demands reimbursement for every dollar spent on your father's nursing home care, plus every dollar spent on hers. It is paid from whatever value remains in the home. Most families only discover this the day that letter appears. They had no clue the state was effectively waiting in the wings for the surviving spouse to die. By that point, the home has usually been promised to the children in a will, and that will is powerless against the Medicaid claim. The only way to block this first method is to remove the home from the probate estate before either parent requires care. So if the property is still solely in a parent's name at death, the first method of recovery by Medicaid is almost inevitable. The second way Medicaid secures your home occurs while your parent is still alive. It stems from a rule often called a TEFRA lien, based on the Tax Equity and Fiscal Responsibility Act of 1982. This law permits states to place a lien on the residence of a Medicaid beneficiary who is deemed permanently institutionalized in a nursing facility. The word permanently is crucial here. Here's how it unfolds in practice. A parent is admitted to a nursing home for ongoing long-term care. Medicaid begins covering the monthly fees. The state then evaluates whether the parent is likely to return to the home. If the state decides the parent is permanently institutionalized, meaning they are not expected to go back home, it records a lien against the house. This lien does not force a sale as long as the parent is alive. However, the moment the parent dies, the lien becomes enforceable. The state recovers its money directly from the property before probate begins, before the will takes effect, and before the family can intervene. This differs from a standard probate claim because the lien is already recorded on the property's title. That means the family cannot sell, refinance, or transfer the home without first paying the state in full. In many instances, the lien balance increases by around $10,000 per month as Medicaid continues to pay nursing home fees. If the parent stays in care for 4 years at $120,000 annually, the TEFRA lien grows to $480,000. If the property is worth $350,000, the state absorbs the entire house and the family is still left owing more. One Indiana family discovered this in the harshest way. After a fall, the father was admitted to a nursing home. Within 90 days, the state labeled his stay as permanent and filed a lien against the house. The daughter drove past that home every week, unaware that the lien existed. 3 years later, when her father died, she went to list the home for sale and found a state lien of $270,000 already attached to the title. For 3 years, she had been paying property taxes and homeowner's insurance from her own pocket on a place she would never receive a dime from. There is a limited protection. If a sibling of the Medicaid recipient lived in the home for at least 1 year before the nursing home admission, the lien cannot be imposed. There is also protection for an adult child caregiver who lived in the home for at least 2 years and provided care that delayed the move to a nursing facility. However, these protections require documentation, and that documentation must be filed in advance. So the second way Medicaid claims your home is by securing a legal interest in the deed while your parent is still alive. The third method is the most far-reaching. It exists only in certain states, but if your parents reside in one of them, assets they thought were safeguarded may not be. This system is called Expanded Estate Recovery. Federal regulations give each state the option to extend recovery beyond the traditional probate estate and seek repayment from assets that normally bypass probate. Over 20 states have adopted some form of expanded recovery, including New York, Massachusetts, Connecticut, Rhode Island, Ohio, Tennessee, North Dakota, Iowa, and others. Under expanded recovery, the state can reach property that older adults were usually told would avoid probate entirely. This can include jointly owned property with rights of survivorship, life estate and remainder interests, assets in living trusts, transfer on death arrangements, and payable on death bank accounts. Life estates are especially misunderstood. Tens of thousands of families execute life estate deeds that let the parent live in the property until death, at which time the house automatically passes to the children. In a state that limits recovery to the probate estate, this setup works, and the government cannot touch the remainder interest. But in a state with expanded recovery, the government calculates the value of the parent's life interest on the date of death and recovers that share of the home's value from the children. The older the parent at death, the smaller that share, but it is almost never zero. Here is what that looks like in reality. A parent puts the home into joint tenancy with a child, believing that when the parent dies, the child becomes the sole owner and the state has no claim. In a purely probate-based state, that approach works. In an expanded recovery state, however, the government determines what portion of the home the parent still owned at death and takes that percentage from the child. If the parent's share was 50%, the state takes 50% of the home's value from the child. The child may have to sell the property or borrow against it to pay off the claim. The same outcome applies to many living trusts. Families spend large sums on lawyers to set up revocable trusts specifically to bypass probate. But in an expanded recovery state, the trust does not shield the home. The government recoups its costs from trust assets as though they were still in the probate estate. One Connecticut family learned this at a painful cost. The parents created a revocable living trust, titled the home in the trust's name, and believed the property was safe. The father then spent 2 years in a nursing facility on Medicaid before dying. The state filed a $240,000 claim against the trust. The trust paid it, and the mother had to sell the home to cover the remaining balance. She moved in with her daughter at age 79. So if your parents live in an expanded recovery state, many of the common protect the house strategies you may have heard about might not work at all. The only meaningful protection is an irrevocable trust established more than 5 years before Medicaid benefits begin. Virtually everything else remains exposed. The fourth way Medicaid ends up with your home is by tightly restricting the one emergency relief option Congress included. This is the hardship waiver, intended to shield families when estate recovery would cause extreme hardship. On paper, the waiver exists nationwide. In reality, states reject most applications. To obtain a hardship waiver, heirs must prove 2 things. First, that the estate assets are their only source of housing or income. Second, that taking those assets would push them into poverty or homelessness. Both requirements must be backed up with bank statements, tax filings, and sworn statements. Even when heirs satisfy both criteria, states frequently deny waivers over technicalities. Maybe the filing deadline was missed. Maybe the residency evidence is deemed insufficient. Maybe the heir owns another property that could theoretically house them. Maybe the heir is employed, so the state concludes they are not truly destitute. One of the most common denials hits adult children who moved back home to care for a parent. Federal rules allow a specific caregiver-child exemption if the child lived in the home for at least 2 years before the parent entered a nursing home and provided care that postponed that move. But states demand proof that the care directly prevented the parent from needing nursing facility care. That kind of proof is extremely difficult to produce, so most caregiver claims are turned down. An Ohio family requested a hardship waiver after their mother passed away. The son had moved back and cared for her for 18 months. The waiver was denied because he fell 6 months short of the 2-year requirement. He was forced to sell the home for $290,000 and send the full amount to the state. At age 62, he had no other place to live. There is a simple reason waivers are rarely approved. Every dollar the state recovers from the estate of a deceased Medicaid recipient is a dollar the state retains. Federal matching funds are calculated after those amounts are recovered. That means the state treasury benefits financially from rejecting hardship claims. Some states even outsource recovery to private contractors who earn a commission on every dollar collected, which means the person evaluating a waiver request is personally rewarded when they deny it. As a result, the hardship waiver is not a broad safety valve. It is a very narrow passage with a high bar to clear, administered by people who have every motivation to keep most families out. The fifth and final method Medicaid uses to capture your home is the one that almost nobody anticipates. And this is the one I mentioned at the beginning of the video. Many people have heard about the 5-year look-back rule and assume it only matters before someone starts receiving Medicaid. They think that if a parent deeds the home to a child, then applies for Medicaid within 5 years, that transfer simply causes a temporary penalty where Medicaid will not pay for care. A lot of families accept that penalty and try to plan around it. But there is a second version of the look-back rule that comes into play after death. If a parent transferred the property within 5 years of receiving Medicaid and then died during the penalty period, the state can treat that transfer as an effort to cheat Medicaid. In that case, the government can pursue the child who received the property and hold that child personally responsible for the unpaid bill. Here is how this trap typically springs. A father deeds his home to his daughter in 2021. In 2024, he has a stroke and moves into a nursing facility. He applies for Medicaid. Because of the prior transfer, Medicaid imposes a 30-month penalty period. The father then dies in 2025, 18 months into that penalty window. Medicaid has already paid for 18 months of care that should have been uncovered by the penalty. The state does not forgive that debt. It files a claim directly against the daughter for the cost of those 18 months. At typical rates, that might be about $180,000. The daughter must either pay from her own resources or lose the home to a lien placed against her personally. This happens because the look-back rule is not merely a waiting period. It is a penalty structure that continues to apply even after the Medicaid recipient's death. The state can pursue the individual who received the transferred asset, sometimes years later, and courts routinely uphold those claims. That means the one transfer many families rely on to protect the family home, a straightforward deed from parent to child, is exactly the move that can make the child personally liable once the parent passes away. Here's what you should put on your to-do list this week. First, determine whether your state uses expanded estate recovery. Contact your state's Medicaid office or look up its estate recovery guidelines online. If the rules mention joint tenancy, trust property, or transfer on death arrangements, you are in an expanded recovery state, and most typical estate plans are vulnerable. Second, stop doing informal deed transfers. Do not casually add a child to your deed. Do not sign a transfer on death deed without professional advice. Do not assume a standard living trust keeps the property safe. These are the exact tactics that can trigger the first, third, and fifth methods by which Medicaid can take the home. Third, if your parent is currently in good health and does not yet require long-term care, schedule a meeting with an elder law attorney about creating an irrevocable Medicaid Asset Protection Trust. The trust must be funded more than 5 years before any Medicaid application. After that 5-year window passes, the home is no longer part of the parent's estate for Medicaid recovery purposes, and none of the 5 methods we discussed can reach it. Fourth, if a parent is already in a nursing facility, insist on receiving the intent to return home decision in writing. If the admission is categorized as permanent, a TEFRA lien may be filed. If it is labeled temporary or for rehabilitation, the lien cannot be imposed. That classification does not happen automatically. The family has to push for the correct designation. Fifth, if a parent has died and the state has already asserted a claim, do not send payment before getting legal guidance. Hardship waivers can sometimes be negotiated. The total recovery might be reduced. Some claims are defective on technical grounds. A single consultation with a qualified elder law attorney has saved families hundreds of thousands of dollars. These 5 mechanisms Medicaid uses to take your home are built into federal law. The only effective way to prevent them is to act before the state does.